Hello everyone and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Thank you very much, Lucy. Ladies and gentlemen, welcome to our webinar. Are you ready for India's new data privacy and protection regime from wherever you have logged in across the globe today? My name is Prasanjit Chakravarti, and I'm a partner in Khetan's corporate M&A practice group and will be the moderator for today's presentation. Thank you very much for taking out the time to be with us today. We are very, very grateful for the interest you have demonstrated and the support you've exhibited, including all of our clients, associates, and other stakeholders by logging and registering for this webinar, which we are running in collaboration with Lexology. On this slide, you will see the agenda for today's webinar. In short, the format will be a presentation by our two expert panelists whom you can see on the screen, Harsh and Supratim, followed by a Q&A session with audience questions. We've already received several questions from the audience in advance of this webinar. And if you do have questions during this session, please use the facility provided in the webinar portal to raise your questions. If we cannot cover all of the questions during the course of this webinar, we will definitely respond offline by email after the webinar is concluded. Also, please note that a copy of the presentation and a summary of the webinar along with the recording will be shared with you after the webinar is concluded. Just to introduce the topic in brief, we will discuss about the key aspects of India's new data privacy and protection regime. Today, data privacy and data protection are very, very topical issues, not just across the world, but more so in India, because India is on the cusp of its new era of data protection with the new data protection bill in the offing. This new legislation will be completely bring about new changes in the data regulatory landscape. And with that will come new challenges for both domestic and international companies involved in dealing and processing personal and non-personal data as well. Until recently, there had been some speculation and uncertainty as to if and when this bill will be finally introduced and enacted in the shape of a law. That has been clarified by none other than India's IT minister, and it seems that the bill will be enacted later this year in July or August. So this is the time to really wrap our heads around on this very, very pivotal topic, which has a significant influence on the business community. Just to introduce our panel, everyone who has registered for this webinar would have already received an email with full particulars and credentials of our two expert panelists. I will not waste much time repeating or summarizing it. Suffice to say that both Harsh and Supratim are expert with excellent credentials in the data privacy space. So again, without much ado, let me bring in our expert panel members, Harsh and Supratim, who between them will walk us through all we need to know about this topic. Over to you, Harsh and Supratim. Thank you.
Thank you, Prasanjit. I'm going to take you through some of the important aspects of the data protection bill today, and also briefly talk about the current data protection laws in India. But before doing that, I would like to spend a minute explaining the landscape in India. India is looking at becoming a 5 trillion economy by 2024-25, and the government of India is banking heavily on tech. And this is the reason that this data protection bill is very, very important for the government to get right. As you know, that there will be privacy concerns that will be addressed through it, and at the same time there will be some issues with respect to innovation related to compliances, because it will be compliance heavy. So the government does not want in any case that the ecosystem that has been built in India, specifically related to startups and unicorns, should get adversely impacted, and that is the reason the government has spent quite a bit of time in taking all stakeholders' comments and forming various committees who have deliberated upon the legislation. So what we see today is a deliberation which has gone for almost 4 or 5 years. I'll run you through the background when we come to the data protection bill related overview. Today I'll talk about, within the overview of data protection bill, I'll quickly take you through some of the important compliances, the applicability of the relevant provisions. I'll also talk about some of the key provisions related to processing of children data, and also briefly touch upon penalty and compensation related provisions in the data protection bill. With this, I'll start giving you a very brief idea of the data protection laws in India today. Can we move to the next slide, please? So what we have today is Information Technology Act. It is not an exclusive legislation dealing with data protection, but there was a section and certain rules were introduced under those sections in 2011. And that is when the provisions related to data protection were first introduced in India. It only had consent as a ground for processing, and that too for sensitive personal data only. It does not govern personal data or information. The cross-border flow of SPDI, which is sensitive personal data, is also free flow. Only requirement is that there should be adequate protection at the hands of transferee as well, which should be comparable to what is provided by the transferor and in accordance with the IT Act, accompanied by consent or simple contract between the transferor and the transferee. Personal data could flow freely under the current regulations. There are very limited rights available to data subjects, and that is one of the main reasons why an overhaul of this requirement or this legislation took place. Only grievance redressal and some of the very basic rights like withdrawal of consent or amendment or correction provisions were there under the current legislation. Security practices are not prescribed, but ISO 27001 is one security standard that has been identified. Otherwise, reasonable security practices needs to be implemented. Remedies again is very limited, and it's very prescriptive in the sense that data subject in any case will have to explain what negligence took place at the hands of data controller and whether there was any wrongful gain or loss as a result of such negligence, and then only compensation by way of damages can be awarded. So as you can see, it is very prescriptive, and that was one of the reasons why the enforcement under the current framework was very bleak. Another reason for it not being taken seriously was because the Cyber Appellate Tribunal did not function for many years before the responsibility was transferred to another appellate authority called TDSAT, which was a telecom dispute settlement appellate tribunal. However, this framework did not work properly for India. Moving on, can we have the next slide? I will now discuss the data protection bill, which its history and some of the other important aspects. Can we have the next slide? So as you can see on the screen, it started in 2017 is when the Supreme Court of India declared right to privacy as a fundamental right. Justice Sri Krishna Committee was formed by the government to provide a draft PDP bill to India. Wide consultations were held during this process, and Justice Sri Krishna Committee submitted the draft PDP bill to the government in July 2018. The government worked on it for almost a year and tabled the PDP bill before the Indian Parliament. The Parliament referred it back to a joint parliamentary committee as there were certain objections to some of the provisions related to government exemptions. The JPC worked on this for almost 2 years, and last year in December, the JPC submitted its report to the Parliament. The Parliament now has the JPC report, which has the draft data protection bill in it. it is understood that the government is also working on this, and it is expected that by July this year, which is the monsoon session, this will be taken up and tabled before the parliament, and there is a likelihood that it may get enacted as well. So how much time will an entity get once the legislation is enacted? It is 24 months as recommended under the DP bill. Of course, this is very similar to what is there in GDPR. 2 years time was given, but I personally feel that this time may not be adequate for Indian Inc. Mainly because today we are at a level where there are not many data protection provisions that are applicable, and compliances are very, very weak. And to graduate to a very cumbersome and comprehensive legislation all of a sudden will be very difficult for India Inc. Now, there are various timelines recommended. Within 3 months, it is expected from the date of enactment that the Data Protection Authority will be formed. Within 6 months, it is expected that it will start discharging its functions. Within 9 months, some of the data controllers that are required to register, which I'll explain later, will start registering with the Data Protection Authority. Within 12 months, an appellate tribunal will be formed, and after 24 months, it is expected that the entire provisions will become enforceable. Moving on to the next slide, I'll talk about the applicability. As you can see, any personal data processed in India is covered under the DP bill or processed under Indian law. So this is very wide. On the right hand side, you can see non-personal data and anonymized data is also a part of this bill, which means a non-personal data is any data which is not personal in nature. So it is very vast, and it includes anonymized data as well. So this makes the legislation very wide whenever it is enacted in this form. The reason for converting the name from PDP bill to DP bill is also because non-personal data has now been added as a part of this. However, there are not many operative provisions related to non-personal data. It will be through regulations that certain provisions could come in, but there are very few provisions related to NPD, and it is not clear today what kind of processing requirements will be applicable or what kind of rights the government will have with respect to NPD. At the bottom, you can see it is also applicable on data controllers outside India. Data fiduciary is the term used in the legislation instead of data controller as we generally hear. And the reason for this is that there is a relationship of trust and responsibility that is cast on the controller as far as the data subjects are concerned. Again, data subject is not used in the legislation, but in the DP bill, it is the data principles, because they are the focal point of this legislation. Rights are being given to data subjects. They are termed as data principles. So these are applicable. The bill is applicable on controllers outside India also, if they are into the business or systematic activity of offering goods and services to data principals in India. Systematic activity is any activity which is persistent, is more organized and consistent. Profiling of DP in India. So website in US, if it is offering goods and service systematically to Indian data principles or profiling data principles in India, the entire legislation becomes applicable. In certain cases, there are exemptions also. On the right hand side of the screen, you can see not applicable. So government agencies can be exempted in certain specific circumstances like integrity and integrity and sovereignty of India in the interest of those provisions, and we'll look at them in more detail later. Government notification is a unique provision here because India is land of business process outsourcing. In order to exempt any data which is related to data principles outside India, the government has the power to exempt the provisions of the law, and provided certain other criteria are met in terms of contract and all of that, and we'll have to see how this plays. Small entities not defined today, but only those small entities which are not into automated processing will be covered in exemption. And sandbox, as I said, it is the government has tried to build in a provision of sandbox under which exemption can be granted to an entity who is into new kinds of processing or deals in artificial intelligence or machine learning kind of techniques. They can apply to the data protection authority, and the data protection authority, on reviewing the privacy by design policy, can exempt such entities for a period up to 36 months from some of the provisions of the legislation. So this is to ensure that the unicorns in India are coming up as quickly as they are today. We have already more than 45 unicorns last year, and it is expected the numbers will grow this year. Other provisions are very similar to most of the legislation: research, archiving, statistical purposes, domestic purposes, or in fact journalistic purposes are also some of the areas which can be exempted. Can we have the next slide, please? So we can let's look at the grounds for processing. I think this is the most important part of this legislation. Consent, of course, is a big one here, and the consent should be free. When will consent be considered free? It refers to the Indian Contract Act, which requires that there should be no misrepresentation, fraud, or coercion, and then it can be said that it is free. Similarly, it should be informed, which means proper consent notice should be given to the data subject so that all the ingredients are fulfilled and proper information flows to the data subject. I'll not spend time in explaining functions of state. Prompt action could be a medical emergency or a disaster. In those kind of circumstances, the personal data can be processed. Compliance with law and court orders is another ground. Let's spend some time understanding employment and reasonable purposes. Both of these are fairly prescriptive in nature, which means that it is the data protection authority which can add to the grounds. But again, there are a few instances which are recognized in the legislation itself. So employment, it is not necessary that the employer takes consent for every kind of processing. Some of the instances included there are for termination of employment, or for attendance, for giving any benefits, or uh, any reviews that need to be taken by the employer. These are some of the grounds under which employer can process personal data of an employee. Similarly, reasonable purposes is almost like what we have in GDPR, legitimate interest, but with one big difference, that it is again prescriptive, and it is the DPA which will decide what is considered reasonable. Some of the examples that are given in the Act as an example are credit scoring, M&A, or search engines, where it is expected that data will be processed, but through regulations, more instances can be added. So the privilege is not that of data fiduciary to apply and understand whether it is legitimate interest. It is the DPA who will explain, or rather through regulation prescribe what are reasonable purposes. Can we move to the next slide, please? So compliances, we will look at major compliances that are required on part of data fiduciary. Accountability, privacy by design is well known. It's there in many legislations globally as well. But here the requirement is that privacy by design policy should be submitted to the DPA, and the DPA should be satisfied about the policy. So it is more like submitting information and getting an approval. Transparency, it is expected that much more information than just consent notice through various means should flow to the data subject. Information on any fairness of the algorithms used by the data fiduciary, or if there are sets of data that are flowing outside India, that information should be available with the data subject. If there are any data scores that data fiduciary has, those data credit scores should be made available to the data subject. Security safeguards is another important one. There are no specific standards prescribed, but yes, de-identification of information or encryption techniques to be used are considered security safeguards. And Regular assessment of security safeguards should be undertaken, access policy should be defined, and integrity of data should be maintained throughout. So these are some of the security safeguards that are prescribed. Moving on to number 4, which is breach notification. And this is an important one. Similar to the GDPR, there is a requirement of 72 hours, within 72 hours of gaining knowledge, a data fiduciary or controller should inform the data protection authority. However, it is then up to the data protection authority to suggest certain urgent steps that need to be taken by the data fiduciary. It can also direct that the information should go to the data principals, and the data protection authority can also inform the data fiduciary to keep this information on its website so that anybody visiting their website can know about the breach that has taken place. Grievance redressal is again an important one. Within 30 days, satisfactory redressal of grievances should be made by the data fiduciary. If it is not done, then the data protection authority it is the data protection authority to whom a complaint can be made. Number 6, 7, and 8, there is a small star you can see. It is only applicable on significant data fiduciaries. Significant data fiduciaries are those data fiduciaries who are into large processing of personal information or data. They may be processing data which can cause significant harm, or are social media platforms, so, or maybe into processing of children data. So depending on this, a criteria or threshold will be later on released, and one may be considered as significant data fiduciary. If that is the case, then first of all it needs to register with the authority that they are a significant data fiduciary, and upon registering, these obligations in 6, 7, and 8 will be in addition to the other obligations applicable. Data protection officer is a very important one. A key managerial personnel will have to be designated as a data protection officer, and by key managerial personnel, it is meant that he should be at the level of a CEO, CFO, or a company secretary, or an independent whole-time director. So this has been widely criticized by various stakeholders because it requires a lot of effort to wear two hats at the same time, offer managerial services at the same time, become a DPO. But this is a requirement that the data protection bill has today. Record keeping and data audits. So annual audits by independent data auditors need to be undertaken, and some data scores will be made available to significant data fiduciaries. And this, as we saw, that this has to be published as a requirement under transparency requirement. Impact assessments need to be taken by any significant data fiduciary if they are processing information which can cause significant harm, or it relates to biometrics or genetic data. Then impact assessment needs to be undertaken first by a data fiduciary, and it needs to be submitted to the data protection authority. If it is satisfied that the impact assessment has been properly done, then only it will grant permission to have that kind of processing undertaken. Can we move to the next slide? Data principal rights, again, it is very similar to most of the other legislation. I'll not take much time. It is self-explanatory. Right to be forgotten is a little differently placed than GDPR, because if this right is exercised, then it restricts further disclosure of personal data by a data fiduciary, and the right is not available with the data fiduciary to decide if somebody wants to exercise it. It is again with the data protection authority. There is an adjudicating officer to whom an application needs to be made for right to be forgotten. That person will assess whether the rights of others related to freedom of speech and expression and right to information is not curtailed because a data subject is exercising this right, and then a decision is given and it is appealable. Right to portability is another important one, and it is only applicable if automated means is applied by the data fiduciary while processing data. and it not only includes data which is personal, but any inferred data is also part of right to portability. A fee can be charged by the data fiduciary for right to portability or right to be forgotten, but other rights such as confirmation, access, correction, or erasure are free of cost available to the data subject. Can we have the next slide? So we'll look at a couple of key provisions under the data protection bill. We can move to the next slide. Children data is an important one. The age of majority is 18 years in India, and the same has been recognized under this particular bill. I know there is a vast difference between the age in EU countries and US, which could be anywhere between 13 to 16 years, but this is the age prescribed under the DP bill for gaining majority. Consent of parent will be required before processing any child's data, and the mechanism of taking consent will be provided through regulations by the DPA. Profiling targeted advertising is not allowed as far as children data is concerned, and there is an exemption to certain children counseling organizations, but those will be elaborated through regulations. And this is a very unique provision, and it is only a recommendation from the JPC that 3 months before attaining the age of majority, a child should be given a notice or information that after 3 months he can exercise his right under the legislation and provide his consent. Can we move to the next slide? Coming to the final slide related to penalties and compensation. Penalty is very similar to GDPR, where there are two classifications. The higher slab is 4% of the worldwide turnover, or USD 2 million, whichever is higher in case of certain fundamental breaches, like without consent, if personal data has been processed, or there is a child data that has been processed in violation of the requirements. And there is a lower slab of 2% or USD 650,000, whichever is higher in case of certain breaches by significant data fiduciaries or violation of data breach related provisions. Imprisonment again is an important provision. There is just one offense of re-identification of data intentionally done without the permission of the data fiduciary, in which case 3 years of imprisonment or fine up to 2,500 or both is possible. Who can be imprisonment is an important question. Who can be imprisoned is the bill requires that anybody who is in charge of the function to which the offense relates can be considered as a person responsible. However, if such person can prove that he is not aware of the offense that has been committed, or he took all due diligence steps to avoid but it still happened, there is a possibility of creating those kind of defenses. Compensation again is a direct compensation right is available with data subjects, and available with data subjects as far as data fiduciaries are concerned. Can we move to the last slide, please? So key takeaways, as we have seen that the applicability of the legislation, proposed legislation, is quite wide. It has specific provisions where NPD is also added. Grounds for processing are very, very prescriptive, in the sense that reasonable purposes will be explained by DPA through regulation and is not left to the data fiduciary to decide. Compliances of significant data fiduciaries are very tough. As we just saw, annual audits, etc. are required. And the maximum penalty is not as high as GDPR, where it is much higher in terms of amount, but individuals do have a right to seek direct compensation, is something which is evident in the act. So with this, I will hand it over to Supratim to take you through some of the critical provisions of the legislation and also talk about the implementation strategy. Thank you so much.
Thank you, Harsh. So I think Harsh set out an appropriate background for all of us to take this to the next stage, and that is talk a little more about the Data Protection Bill 2021. Some of the critical elements we would be talking about, such as localization and cross-border data transfer, which has been in the eye of this. I would say it's created quite a furor. And government exemptions, which is the next very critical item, which is perhaps an item which would be getting hotly debated in the parliament. Social media platforms getting included in the data protection bill is the next thing. And otherwise, we will do a bit of comparison with GDPR and our law, and perhaps we'll see how it is not the same. Okay. When GDPR came into effect, I remember one of the financial institutions in the country got a consultant and tried to be GDPR compliant or get that standard implemented. And we were told that, why don't you still do a dipstick analysis just to check if there is anything amiss from an Indian law perspective? But we don't think so, really, because we are already following the global gold standard. And we started looking into the system. We started with some basic issues, right? Firstly, say age of consent, which is 18 years in the country today. It's 16 years under GDPR. It can go below up to 13 years, depending on the member state. Uh, Financial data, which is considered to be sensitive personal data or information, even today in the country, in India, GDPR does not consider this to be in the special categories of data. Right to be forgotten, like Harsh was mentioning, is very differently written in the upcoming law that we'll be having. It's not akin to what you would see in the GDPR. So we have to be careful when we are trying to adopt these global gold standards. It has some tweaks, some very important tweaks when it has gotten legislated into our upcoming law. So with that, I will get started. Next slide, please. The next, this important slide, it talks about what do we have as, this concept of data localization and cross-border transfer. We are all aware that there are several theories and counter theories to data localization. For example, there's this trade theory that this is my data, my oil, I should be using it the way I want to. There is security theory, where Indian law enforcement authorities are saying, listen, when we need access to some critical information, it is often told to us that this data is housed somewhere outside the country, and we are finding it difficult to do, say, to carry out law enforcement related activities because mutual legal assistance treaty type solution is too time consuming. So what do we have, as a law right now in the DP Bill 2021 in the draft? As per that, draft, personal data can freely go out, no problem. Sensitive personal data continues, to continue to store in India. However, there are certain conditional transfers which are possible. And what are those? You need to have explicit consent. Along with that, you need to have either intra-group scheme or adequacy decision, or it has to be approved for specific purposes. If these are there, then you may send it outside the country for processing. Critical personal data should continue to be stored in the country. In GDPR, as we are aware, the scheme is very different. It is all set out in the slide. There is no hard localization, no differential condition of cross-border transfer of this nature, at least. I'm just now cognizant of the time that we have. We want to keep enough time for Q&A. We'll quickly move on to the next slide. So, the Joint Parliamentary Committee, which was last handling and trying to give inputs on the last version of the bill, gave some inputs which have created, I would say, more furor or put more fuel to the fire. What has it done? It has given the government more expanded role in approving cross-border data transfers. They have put in touchstones such as public policy and state policy for approving contract or intra-group schemes. Carte blanche powers have been given to government and its agencies from the applicability of law. However, it also says that a just, fair, and reasonable proportionate procedure or safeguard and oversight mechanism should be set out in case there is an exemption being given to the government agency. So the way it has been looked at by civil society is quite critical, and they're trying to see that there are edits or amends made to such recommendations, and it does not find its way into the final version of the bill. Next slide, please. This is an interesting one where suddenly we found social media platforms getting included in a data protection bill. Just to tell you, we always set sailing to prepare a umbrella mother legislation on data protection. We never thought that minuscule aspects such as social media platforms, which may be having some touchstone of data, but really cannot form an element under this bill, would find its way. Such recommendation has been made. And again, we are through industry bodies, etc., we are pushing so that this does not really get etched in a data protection law. There is Information Technology Act, there are rules under that. It should, these are better avenues, we believe, where these requirements, regulations should be passed. But in any case, what has been told, it's been told that there would be liability for content being hosted from unverified accounts. So you get onto a platform, you'll verify yourself, you'll have that blue tick or a green tick where you are shown as a verified user, and then you carry out certain activities that would be okay. But if it is an unverified account and they are hosting certain content, then there could be liability. Then they are saying that statutory media regulatory authority, just like your Press Council of India, should be formed. Again, we are slightly clueless as to how such a body will operate when the communications are mostly instantaneous in nature. Next is a parent company handling technology should set up an office in India. This, to my mind, should be thought through better, because this could have a widespread ramification for foreign entities, especially on the taxation front as well. Okay, move on to the next slide, please. So I think this next one is in relation to data breaches, and Harsh very nicely encapsulated this point. I would not spend too much time, but the differences are right in front of you. Under Data Protection Bill, personal and non-personal data breaches are now included. GDPR deals with personal data breach only. A breach notification has to be for DP bill. It is all data breaches, irrespective of the harm being caused to the data principals or data subjects. GDPR, no notification if the breach is unlikely to result in a risk to data subjects. Finally, notification to data principals. It is under the Data Protection Bill. If the Data Protection Authority is telling you to go and inform, then you have to do so. Under GDPR, it has to be done in the event the breach results in high risk. Next slide, please. Applicability. I think, again, Harsh has very nicely explained. It is exactly like GDPR minus one difference, which is important. Under upcoming Indian law, the foreign company can be falling within the purview of the law if they're carrying out a business in India. If you see that this third box, it's saying business carried out in India. What we have requested the ministry is that to get some more clarity around this, either define what is business carried out in India. Otherwise, it could be a one-off transaction which could suddenly get under the purview of the law, and that could be unintentional. This is not there in GDPR as well, and we have tried to draw a parallel and give some explanation around this to the ministry. Next slide, please. These are grounds of processing, excellently mentioned, elaborated by Harsh, but I will just pick up 2-3 points of similarity, dissimilarity. One is reasonable purposes. Like Harsh mentioned that, this bucket under Indian law covers the avenue of legitimate interest. Right now, that's the recommendation of the Joint Parliamentary Committee, but this is a touchstone, and the Data Protection Authority has to decide whether it would get absorbed and really get legislated and called out, just like you have under GDPR, as a very good avenue and a ground for processing. Employment, again, it was not there initially. We went across the country to be part of the Justice Sri Krishna Committee consultation meets, and we had put forth this point that, listen, employer-employee relationship is very special. So, that needs to find as a special mention in the grounds of processing. Thankfully, it has seen the light of the day, and that's a ground of processing right now. Performance of contract, unfortunately, which is there in GDPR as a ground of consent, is not there in the Indian law yet as a specific item. Next slide, please. Sensitive personal data, I think very important, because they have got a higher threshold of safeguarding. On the left hand side, you see what is there in the present day Indian law as the elements of sensitive personal data. In the center is what you will find in the Data Protection Bill 2021. You see the list has become longer. And you have items like the fourth one, if you see, official identifier, which means all your passport, Aadhaar, PAN card, all these official identifying documents would form a part of this bucket, official identifier. On the right hand side, we have drawn a parallel with GDPR as to what are special categories of personal data. Next slide, please. Penalties. Again, I'm not going through the slide. We are running short of time. But you can see the construct is just like GDPR. Of course, the amounts are quite low, but the framework is quite similar. The first and the second bucket of 4% and 2% is quite akin. The numbers are of course different on the penalty numbers amount side. Criminal offenses, there is imprisonment under the DP bill, and there is no criminal penalty as such under the GDPR. Compensation provisions are there in both, but there is a differentiating factor which Harsh has already mentioned. I would not belabor on that. Next slide, please. The next slide, yeah, we can skip this, is basically what is keeping us busy. What are we doing in order to see that organizations, foreign organizations which have got a touch point in India or say Indian organizations, how do we prepare them? Okay, training and sensitization is the most important one, we believe, and we have to keep in mind that in India we do not have a natural culture of privacy, so we will need time to educate people, and that's what we are trying to do. But remember that one size does not fit all. So what are we trying to do? We are having, say, 3 different categories of training. At the board level, it's a very sharp presentation to get the buy-in from the leadership. Then for the mid-level manager, we have an hour or 2-hour long session where some of the granular details are explained. And the last one is a day-long workshop for say legal team, secretarial team, who will ultimately put this into action. We are also carrying out a gap analysis to check that where are these organizations today and where they have to reach. And this is also helping us in a way because we are able to identify if there are any gaps with the present day law related compliance, and also preparing them for the future law. And finally, whatever is the analysis, we are also trying to provide recommendations how to affect such and attend to those gaps, and that is being done through the recommendations process. Next slide, please. So with this, I will quickly wrap up my session, my part of this particular talk. What have we discussed? We have discussed some unique provisions such as data localization, social media platforms, and government exemptions. We have discussed the changes that would be required in comparison to GDPR. If you're already GDPR compliant, there is some delta, some gap to cover, and preparing early for this law is really the key. Because like I mentioned, and the GDPR experience has also shown us that it will take us time to reach where we want to reach by the time the law comes into effect. So it is better that we start early. With this, back to you, Prasenjit.
Thank you very much, Harsh and Supratim, for a riveting and fascinating presentation. Really, really insightful. Now I think let's straight away see what we have got from the audience. A bunch of questions I can see on my screen. Let me quickly skittle through and raise especially the ones which have not been covered or discussed by you so far. The first one I can sift through is on, will the data privacy bill impact telemarketing like voice calls or SMS sent for marketing activities in India? Harsh, if you can quickly respond to this interesting question, that would be immensely helpful.
Sure, Prasenjit. I think this is a great question, and there is some amount of overlap here in terms of the regulators involved. So, Telecom Regulatory Authority of India is responsible for ensuring that no spam SMS or phone calls go from telemarketers, and there is a separate regulation in place. We also have the data protection bill, which will see the light of the day, and there could be 2 parallels we can draw. Under the TRAI regulation, the task has been assigned to a telecom service provider to ensure through opt-in and opt-out that consents can be managed, and then certain punishments or penalties are prescribed in terms of disabling the telecom resource, and all of that is there. Whereas if you look at the data protection bill, what will happen is telemarketers will need to ensure that there is proper consent as required in the data protection bill, accompanied by certain compliances, as we just saw, related to transparency and security safeguards will have to be deployed. So what will happen eventually is there will be two kinds of sets of laws that will need to be followed by telemarketers if everything in the bill is enacted. What I would suggest is maybe there is an important reference here that I can make to the DP bill where it says that if the same subject is being dealt by more than one regulator, in that case there is a provision of entering into a MOU between the two regulators to ensure that both of them regulate the correct portions and there's no duplicity. So this is a good example where there could be an MOU between the Telecom Regulatory Authority of India and the DPA as and when it is formed. Thank you.
Excellent. So that was a very comprehensive response, Harsh. Thanks very much. I think the second question is in fact a very interesting one, something very close to my heart, being a M&A practitioner. And so, Pratim, if you can shed light on this, the question is really how will this DP bill, the data privacy bill, impact on M&A transactions? Before you respond, let me just amplify a few aspects from my end also as an M&A practitioner, especially in a business transfer or asset transfer, when individual assets are transferred from entity A to the entity B, which is the buyer. How will this whole consent requirement play out? How difficult, how onerous, how big a deal breaker issue is that? And what should buyers or sellers brace up to in terms of diligence, customizing their acquisition list for diligence, the risk mitigation package in the form of warranties, indemnities, representations, including valuation. So how does all of this pan out in light of this proposed bill, Supratim?
Excellent, and I think Prasenjit, this has already started getting played out. I think in the market, the mergers, acquisitions, joint ventures that we are observing. Earlier, we used to have those tax structurings first. Now, interestingly, we are also observing data structuring first, and it is being given due weightage. And like you say, there are two pieces really. Okay, one is the due diligence exercise, and this also gets, I would say, amplified if it's a sector which is regulated, or say where the data is sensitive in nature, pharma, healthcare, financial institutions, banks, etc. So these are pockets where one has to be extremely careful, and there one size does not fit all. That requisition list, which has that one-liner question about the data, will not work. It's a more intense questioning, and the response has to be specific. There are also checks to be done in relation to previous data breaches, what kinds of Q&A would have happened with regulatory authorities, etc., etc. So it is a changed paradigm, and you need to keep your eyes and ears open on this front. That's one. The second piece is how do you do structuring and then risk mitigation. Like you correctly pointed out that in a normal share purchase agreement, perhaps the situation is a little easier because data set or data is not really moving from entity A to B. But if there is a situation like a business transfer agreement or an asset purchase agreement where personal data would be moving, whether it is of employees, whether it is your customers, consumers, then you will have to go back and do a little bit of homework on this. Okay, what kind of consent was taken from these individuals right at the beginning? Was it omnibus enough to capture such a situation? Most of the times we see in the Indian scenario that's not the case. Sometimes you will have some wishy-washy language and people will try to take shelter of it. But if you're an acquirer, you have to apply a very fine lens to see, does this pass your muster? And you're able to actually, are you paying for something for which you're actually getting the worth of, right? So if you could actually take up data which is of no value, if tomorrow after taking that data set, the customers or the employees sue you that this was not rightfully gotten by you. And the last thing is, of course, adequate representations, warranties, and indemnity package, which has to be, in light of the previous two, has to be negotiated. So yes, there's quite a bit and very different paradigm.
Excellent. No, that's I think terrific. And the more I think about it, I think as I speak, I think we could actually end up talking and doing a specific webinar just on M&A issues in data privacy related, aspects. And if there's enough interest from the audience members, I will request them to ping in a line to us towards the end when we do the poll and conclusion. We will take your feedback, and if there's enough interest, we will definitely try and do a specific customized session just on M&A issues, and amplify to what Supratim very nicely articulated. Moving on to the next question, I think just in terms of parity, let me go back to Harsh now. Harsh, this is slightly technical, it seems, but that's why you were there for, I guess. Is the DPA an independent regulatory body in India, or is it dependent on the government? I think interesting question. Maybe you also start off, why is it really important, this question? That would be, I think, important context, I would say.
I think this is a very good question in terms of independence, because this has been widely discussed, and there are certain provisions in the DP bill which I'll talk about. But first, why is this an important question? Because I believe this will have a big impact on how the DP bill is actually implemented. As we all know, that government is one of the largest data processors anywhere, because it has data of its citizens and for various reasons. So if the independence of the data protection authority is not there, which is at the center of it and has wide powers, there is a possibility that the favor can tilt in government's favor, which will make the rights of the data subjects weak. And this is the main reason for this legislation to come, that data subjects should be empowered. So this is a very important question and needs to be deliberated upon, whether the data protection authority is independent or not. Coming to the DP bill, there are two aspects we can look at to ensure independence. One is that within the DPA, there are two wings as prescribed. One is the inquiry wing and the other is the adjudication wing. So ideally, these two wings should not be part of the same authority for obvious reasons. There is a particular provision also, if I remember correctly, in the DP bill, which says that the central government will try to ensure that both these functions are independent. So that is one. Second, if you look at the criteria for appointing the Data Protection Authority members, there will be a chairman and 6 whole-time members. So these will be appointed by the central government on the recommendation of a selection committee. This selection committee has 7 members as of now as proposed, and out of these 7, 4 are in a way government officials. So obviously the government has an upper hand in terms of selection. If you look at some of the other authorities, similar authorities in other sectors like Competition Commission of India, what the competition, the way it is structured is that there are 2 independent members in the selection committee. One is the Chief Justice of India, and then there are 2 officers from the government. So it is more evenly balanced, and to ensure that the selection committee recommends without any bias. So I think this is very relevant, that this is taken up seriously and the independence is ensured. There is wide criticism on this aspect of the data protection bill, but let us see how the government reacts to this.
Thank you very much, Harsh. That was extremely insightful. I think let's squeeze in one more question, I think, before we head towards the fag end of this webinar. I think, Supratim, for you, this is a very interesting one, actually. What is the reason for including social media platforms within the meaning of significant data fiduciaries? So that really does compound the issue, isn't it, by including the social media platform? What's your take on that?
Right. So I think if you read the Joint Parliamentary Committee, Prasenjit, you will understand the bitterness that is coming out from that, from what they have written. It's very clear that, there are problems with social media platforms. It's a fact, okay, or social media intermediaries. But the question that we should answer is, what is the correct avenue? Where do we need to park this? You already have the Information Technology Act. The rules in relation to intermediary liability were overhauled last year. So we believe that that was a good avenue perhaps to have had more checks and balances being put. But like I was mentioning, we had been across all the locations when the Justice Sri Krishna committee consultations were happening. We take extreme pride in telling that we know each and every sentence that is written in the bill, why it is written, how it is written, right? So we never fathomed a situation where a microscopic element of data, such as social media platform, will find a special mention in this mother umbrella legislation. To my, in my personal opinion, it is still incorrect. A better place perhaps is the IT Act and the rules, etc., but not really in this particular bill. So I'll rest. I'll keep it there.
Excellent. That's a very interesting question and an equally interesting response, I would say. And there are actually tons of more questions. Unfortunately, there are 4 minutes to really go, and we need to get onto the poll slides and the conclusions, some very important pieces of information for our audience members. So I will, with due apology, and take the liberty to move on. But of course, as I mentioned at the very outset, we will respond to each and every question. Now you will see on your screen the audience poll. We will request you to take 30 seconds to respond to this poll slide, and we provide you feedback on today's webinar. We take this extremely seriously as part of our continuous improvement program. Lucy, can you please put up the poll slide? So while you guys put this in, I think when we go back to the last 3 minutes, I will share some interesting facts about how do we continue to stay engaged on this topic, and what else we can do, including maybe a follow-up webinar when the bill is crystallized into law, or even a specific session on transactional issues, especially mergers and acquisitions. So I think that's the poll. So we head to the conclusion now. I think to conclude, I would like to first thank our panelists for sharing their experience and expertise with us today. Harsh and Supratim, you did a remarkably good job. Thank you so very much. In a very, very tight time list, you did an outstanding job, really. Special thanks also to Lexology for partnering with us on this marquee event. Last but definitely not least, to our audience, you are the ones who make this a success, isn't it? And I hope you found this webinar a worthwhile investment of your time, and very interesting. We certainly thoroughly enjoyed this bringing to you. You will also separately receive a request for feedback on this webinar. Please take the time to give your feedback, comments, criticism, even compliments. Everything is most welcome. The form barely takes a minute, so please take this time. This will really set us up nicely for the later part of the year when we do our follow-ups and all that, and spend the time. Should you need any further questions, information, clarifications, please don't hesitate to reach out. Our details are there on the screen and in the slide deck towards the end, which will be sent across to you. And thank you once again for attending today's webinar. We look forward to being of service once more in the near future. Till then, stay safe, take care, and all the very best. Thank you very much.